Welcome to yet another BW Legal World dialogue. Yesterday, BW Legal World spoke to Mr. Quinn of Quinn Emanuel on how does he see the entry of law firms, foreign law firms in India panning out. Today, we are going to talk to a stalwart, an icon, a lighthouse of the legal services domain. And I don't use the term lighthouse lightly. When I give away his name, I'm sure the word lighthouse and legal services go together with his name. Let me welcome Mr. Lalit Bhasin to this BW Legal World dialogue. Thank you, Mr. Bhasin. Let me start by asking, you completed more than 6 decades in this profession. How has the legal profession changed in the last few decades? And what has not changed about the legal profession in 6 decades?
What has not changed is that in India we still consider this as a profession. What has changed outside India is that it has become a business. But here we stand committed to our values, our traditions, our culture of giving to the society as lawyers, which I think the shining examples are our father of the nation, Mahatma Gandhi, the first president of India, Dr. Rajendra Prasad, the first prime minister of India, Pandit Nehru, then people like Dr. Ambedkar, Sardar Patel, they all belong to this profession. And this profession has been playing a very significant role as in the legislatures also, in the executive also, whether it is the BJP government or the earlier UPA government, and all lawyers were always very prominent, holding very important and key positions. So that is the role of the profession as I see. That has remained unchanged. But the system of administration of justice has definitely taken a beat in the sense that people in India, our citizens, they are not getting justice, you see, from the courts of law. It is, one can't blame the courts of law, but it is the type of system that we have. We are by nature, very litigious people. And at the moment you have nearly 5 crore cases, which is the official figure, and this figure must be mounting. In our constitution, we have a preamble that we secure to our citizens justice. Justice is the first word, social, economic, political. But are we getting it? No, we are not getting it. From justice, emphasis has shifted to law. Law means regulations, rules. There is no self-regulation. There's emphasis, you see, from justice to law, with more and more laws coming in, more and more regulators coming in, it leads to more and more disputes. So there is no end to the disputes. There is no solution. That is why litigation has failed in India. People were thinking of alternate dispute resolution in the form of arbitration. Now people are looking for an alternate to arbitration.
Absolutely, because arbitration was seen to be an alternate to mitigate the long delayed process of judgments. And second is the cost. Both on the timelines and the cost, arbitration seem to have not fulfilled its purpose yet. You know, it's in fact has become even more expensive.
More expensive. You are absolutely correct. It's become delayed. Arbitration has become very delayed because it is generally conducted, you see, by the retired judges, either of the Supreme Court or High Courts and all that. They are flooded with arbitration matters, and the dates they give is after 5 months, 6 months, and they are very expensive. Therefore, instead of strengthening our litigation structure, court system, we are now trying to create arbitration, but that has failed to take off. for the very simple reason we do not have good arbitration institutes in this country, which inspire confidence with the parties like you have in Singapore. Can you imagine that two parties in India, Indian parties, if they have a dispute, they would like to go to Singapore to get the dispute resolved rather than have the matter settled here. Therefore, the only answer is to promote mediation, settlement, samjhota, agreements. And that is where you see the present generation, young lawyers, the law students, there has to be a change in their mindset to promote settlement of disputes. The law schools should have some course on developing negotiating skills. Negotiating skills even with in the general counsel or the in-house counsel. Before a dispute becomes litigious, you see that it will go to the court. People should try to resolve that. Therefore, we have to go back to our ancient system of consensual form of justice, where panchayats, they used to resolve the dispute that they were not dispute, differences among people. Panchayats. Then we had Zilla Parishad. Even during the Mughal times, we had what we call Adle Jahangir. Adle means the justice. Jahangir's justice. There was no law. Emphasis was always on justice. But it is the British people who brought in this 3-4 tier system, which suited a small country like UK. But it doesn't suit a country like India, that we start with a sub-judge, then it goes to the district judge, then it goes to the single judge of High Court, then division bench, sometimes full bench, then Supreme Court. Supreme Court also 2 judges, then 3 judges, Constitution benches, 7 judges. This is what is happening today. So we have to go back, you see, to our ancient times to develop, you see, that consensual form of administration of justice. But it's an uphill task because we have a constitution which sanctifies this present system. And there is no turning back. One can't criticize the constitution because it's the framers who possibly thought about it that British system is the only way. But some thinking has to be there.
We have to evolve. We have to be contextual. We have to learn from what has not worked in the past and is not working now. Now, you already summed up what needs to be done to be able to deliver justice. If you had to sum up in bullet points the 3 things that are possible to be done, some may be a little more idealistic and may take more long-term, kind of intervention. But what can be practically possible in the immediate future?
What can be possible is to have these notorious laws delays at least reduced, and are 3 things. Government is the largest litigant. If there is a change in the mindset of people, mindset of the government official, that we have to resolve disputes, not keep on ego. If one court holds against them, they must file an appeal and go in revisions and all those things. Therefore, government, if it takes an effective step, then litigation can be reduced, you see, in one go. Second is we have too many laws. We have overlapping laws. We have outdated laws. 1800 something, Evidence Act, Contract Act, CPC, CRPC, Indian Penal Code, Evidence Act, all these laws. So there should be more reliance on self-regulation. Have faith in the people, have faith in our systems. And then these are the, factors which can reduce. And don't have more laws coming in.
Sure.
Because that means, as I said earlier, more regulators, more disputes and all that. So these are the factors which can help in reducing these huge pendency of cases.
Thank you, Mr. Bhasin. I hope the policymakers and the powers that run this country are listening. And I hope, like the Prime Minister has been a progressive force in lots of areas, if he can make a difference in this, I think he can leave an imprint on the nation like never before. Now, let me come to law firms. In the last 2 to 3 decades, law firms have become the preferred place for a lot of bright legal minds to work, at least to start with, and then they branch on their own to create their own law firms or go into in-house legal departments. You started the Society of Indian Law Firms long time back. How did this idea of starting a society for Indian law firms came about?
Well, the idea, you see, it came about in mid-90s when liberalization of economy was taking place. So it was that time that in addition to the earlier traditional law firms, like we had Mullah and Mullah and Amarchand Mangaldas and Crawford Bailey,
And J.B. Dadachandji.
J.B. Dadachandji, except for these few spread in 4 or 5 cities of the country, there were hardly any law firms. But liberalization brought in, you see, a whiff of fresh talent and young people, young lawyers with good resources, with good knowledge, with good competence, and with some knowledge about technology. They started setting up their, what we call today startups, you see. It all started with the law firms at that point of time. And by the year 1999, we had a galaxy of good emerging law firms. And they were brilliant and they were second to none. At that point of time, this threat came, which threat was there from 1994, when I was the General Secretary of the Bar Association of India and Fali Nariman was the President. First time the government brought in the move to bring in foreign lawyers. We in the Bar Association vehemently opposed this because we knew that the Indian legal profession is not yet ready to face that challenge, to face that competition, to face the huge resources of these foreign lawyers. Therefore, in 1999, some of the leaders, the managing partners of the law firms, 5, 6 of them, they asked me, you see, for a meeting, and we had a meeting at that Nehru Place Hotel.
Heroes.
So, and over lunch, this idea was, you see, muted that we should set up a society, an organization which should consist only of the law firms, no individual members, only law firm to safeguard the interests of the law firms. Now that was a unique move because in the world there is no organization which has only law firms as members. And they asked me to preside over this institution. So this was inaugurated in the year 2000 by the president of the International Bar Association. There was a lady, Diana Kemp. She came at my invitation to inaugurate this. Arun Jaitley at that time was the Minister of State for Law and Justice. He was also our guest of honor, and of course Fali Nariman. So 2000, we started this, and our first event took place in Mumbai when Honorable Justice Bharucha, he addressed us, and Arun Jaitley said that we will have full safeguards if foreign lawyers come to India. But legal profession should not oppose it. But we kept on opposing it till 2014 when I noticed that Society of Indian Law Firms has on its rolls nearly 80 eminent law firms of the country. So I knew that now we can face the challenge which can come because we are second to none in terms of even resources, technology, competence, speed. Speed possibly we are more, you see, effective than foreign law firm. So 2014 we officially at a meeting convened by the nodal ministry, that is commerce, because WTO and GATS and all that comes the Commerce Secretary presided over an interministerial meeting where PMO was involved, where Ministry of External Affairs, Ministry of Home Affairs, Ministry of Finance, Ministry of Law and Justice, they were all involved. And they asked our views. So I made a presentation on behalf of the Society of Indian Law Firms, putting on record that we do not oppose now the entry of the foreign law firms and lawyers into India, because we can face the challenge in a sporting way, in a spirit of what I call cooperation. You cooperate and compete. That is the spirit in which we are ready now. So you bring them. And surprisingly, the Ministry of Commerce also made a presentation there, and it was almost on the same lines. The same lines meant allow them in a staggered way. And Singapore was the model, which you see we said, Singapore, you follow that.
Because they are allowed in 1983
83.
in a staggered way.
Correct. Since 83 and today also, foreign law firms can practice Singapore law. They can have Singapore lawyers there engaged with them. But there are certain areas which are quite
Out of bounds for them.
prohibited for them, out of bounds for them. Defense, economy, and
Sovereign
foreign
things
policy,
dealing with sovereign issues.
Sovereignty. Anything to do with the sovereign functions of the government, that they are not entitled. But that is a model which is quite successful and which has been followed.
So, last week this announcement, so to say, was a midnight announcement, came out of nowhere. Though you said a couple of months back, or weeks back, the Commerce Ministry had consulted SILF and there was a meeting, but in the sense that you had no inkling that it was going to happen so soon. So what is your reaction to the opening up? Since 2014, you have been for a phased opening up of the entry of foreign law firms in India. So what, of course, you welcome the step, but what can be better in terms of implementation? How do you make sure that it benefits the Indian jurisprudence system, the lawyers, all the stakeholders, and it creates a win-win for both the institutions?
You see, it's a very strange development which has taken place, because only last month, not even 30 days ago, the Commerce Secretary had again convened a meeting where I, as President of SILF, and Bar Council of India were invited to find out that very well you don't oppose the entry of foreign lawyers, but how is it that we can upgrade, you see, and facilitate Indian legal profession, law firms, to compete favorably with them. Now, that was the last thing, and we said you have full support, and they said we'll have more meetings and all that. It is possibly either that left hand doesn't know what right hand is doing, if there are two ministries involved, or it has been moved possibly due to some pressures from the highest authorities, that very well, regardless of the consequences, you just issue the notification of the rules. Because this obviously was done by Bar Council, which reports to the Ministry of Law and Justice. They don't report to the Commerce Ministry. So even Mr. Lakshmi Kumaran, who is our very distinguished member, Senior Vice President, he has been officially engaged with the Ministry of Commerce as an advisor on these FTAs and taxation issues. So he was like a bridge, you see, between the Commerce Ministry and ourselves. So when these midnight regulations declaration came, he was also shocked. He said, Ministry of Commerce, they don't know about it. So this was done. And if you see very carefully, one part is the regulations, Other part is like a preamble to the regulations. A long preamble trying to justify why these regulations are being brought in. And that is where the cat is out of the bag. They specifically mention United Kingdom, the delegations coming from there, the president of the Law Society of England and Wales, whom I had also met. And I say we are fully supportive, but let them come out with regulations, rules and regulations, that let them consult us. We have given them our draft to the Bar Council way back in 2016 as to what should be the terms and conditions on which you should allow. If they had just followed it, there would have been no problem. So the problem has arisen because of this FTAs being which are now pending with Australia, with the UK particularly. UK, the Deputy Minister of Justice, Madam Jo Farrar, she had come here. She met me also, and we said that the regulations will come after consultation with us, and there is no problem now. It may take 6 months, 1 year, but the entry of foreign lawyers will be allowed, and we are fully supportive of that. But this is what happened. Now the regulations have come suddenly. How they have come, what pressures have been at work, we don't know. Suddenly it has come. So if it
But
is,
Mr. Bhasin, now the train has left the station, and I believe in the meeting that you called on the 20th, which was on the Monday, and we are on a Thursday, there was a consensus that which you championed, that rather being confrontational, we should welcome this and work with the government and the stakeholders now to implement it in the right way. Can you tell us what happened in the 20th meeting? The train has left the station. So,
you see, what everyone felt was, firstly, that we want there to be rules and regulations. Rules and regulation not one-sided. You may allow the foreign lawyers to come, but at the same time, you have to internally liberalize the Indian profession also. There are shackles on us, you see, that we cannot have our proper websites. But they call it advertising, they call it publicity.
soliciting business.
We don't want, you see, that sort of what is happening in US. You publicize on electronic media. Okay, if you want a divorce, I'm the best lawyer. If you have met with an accident, I will get you the maximum compensation. I am the ambulance chaser. No, we don't want that sort of, but we want at least dissemination of information
Of the credentials.
Credentials,
Our
activities,
strengths.
our expertise, who are the people you see running it, what are our areas of practice, where all we have our offices in India. So that is all. And then we can't have more than 20 partners. And these foreign law firms, they have hundreds and sometimes
No, I interviewed somebody yesterday who had 1,200 partners.
1,200 partners. So we can have lawyers, 100 lawyers, 200 lawyers, but not partners. And then what we felt was that it has been done in a
Hasty way.
grave hurry, for the reason that possibly they have not understood the implications of the Supreme Court judgment, which came in the year 2018, where the appellant was, the petitioner was the Bar Council of India, challenging the Madras High Court judgment in Balaji's case, where Madras High Court had said only Indian citizens can practice law in India, but foreign lawyers can be allowed on fly-in, fly-out basis. They can also come to do periodically some arbitration matters and all. These were the two exceptions made. But this was also challenged by the Bar Council of India in the Supreme Court. And the Supreme Court held in very clear terms that only Indian citizens can practice law in India. And then they went on to elaborate what they meant by practice of law. Practice of law, they said, does not just mean appearance in courts. Practice of law also includes all transactional work, corporate work, multinational companies, joint ventures, and IPOs and everything. That is, you see, the corporate law. And significantly, our interpretation is that it meant practice of any type of law, not just Indian law. Supposing a British firm comes here, it sets up their office and starts advising on British law. That is not permissible because you are setting up a place for practice of law.
And that has to be on our soil,
Yeah.
governed by our rules.
Our rules.
And they have to be accountable to our laws and our jurisdiction.
That is, and how do they overcome the effect of this judgment? Therefore, they are running a grave risk. You see, we don't want our country to become a laughing stock in the eyes of our foreign communities outside. Look here, they did not even look into the Supreme Court judgment, which very clearly prohibits them from practicing law in India, because Supreme Court is bound to strike it down. Anyone can challenge. You see, Society of Indian Law Firm will not challenge it. We have put on record there.
That also shares your own confidence in your own community and the capabilities of Indian law firms, which you believe is second to none.
Second, yeah. And then this is what they have overlooked, the impact and effect of a Supreme Court judgment. Therefore, my suggestion since 2018, after this judgment came, to the Minister of Law and Justice, to Mr. Piyush Goyal, who very well understood the intricacies of this, I say amend the Advocates Act. A simple amendment is required. Very well, Indian citizens can practice law in India, but the Bar Council of India, under certain rules and regulations to be framed, may allow also the foreign lawyers to come and practice in India. Simple. But they overlooked that aspect, you see. They came out in a hurry with these regulations and running a grave risk, you see, for our country also. Not just the rules and regulations being struck off, but our government will be attacked. How did you allow this to happen? And then assuming, okay, Supreme Court judgment has been overlooked. But the fact is that the regulations as framed also go contrary to the provisions, existing provisions of the Advocates Act. For instance, disciplinary action. Bar Council of India cannot take disciplinary action for any professional misconduct committed by a foreign lawyer, because the rule is that it is the regulatory body of that jurisdiction, their home jurisdiction, which will take action. That may take years, and then it may not be a professional misconduct in that jurisdiction. It may be permissible there. For instance, contingency fee. We cannot take any because that is prohibited. But in so many foreign countries it is allowed.
Yeah.
If someone takes a contingency fee and no one can file a complaint with the Bar Council of India, or if they file it also, they will refer it to that country there, who will decide when they will decide.
And even in a country like US, Arlington is very different laws than New York. Every state is like a, they have their own.
Every state is like a different country,
yes.
So far as the laws and jurisdictions are concerned. Even from one state to another state, to allow one to practice, you see so many permissions and approvals.
Absolutely.
And you see
Absolutely.
about that. That is a grave area, and there is no level playing field when they talk of reciprocity. Now, reciprocity means what?
Will we be allowed to practice in the UK?
No, reciprocity also means, that's a valid point. Reciprocity, say, a firm like Baker and McKenzie, which has about 100 offices all over the world. Which country you are asking reciprocity from? Which country?
So you have to be very specific about it.
You have to be like, okay, one country, like in India we have. India, whatever the central government or Bar Council of India decide, that is final. That is binding on everyone. But this may be binding in each country, but if a firm has got branches all over, how can, what is the principle? And then reciprocity, you gave example of UK. Yes, UK allows on paper foreign lawyers to register themselves, but they don't give work permits.
So it is.
They don't give visas.
So it is only in theory.
It's in theory. So they don't give that. So how do you have reciprocity?
Let me also. So clearly, we need to fine tune what has been set in motion. Let me put it this way. Now, I understand. Correct me on the meeting that you did, and I think the meeting went on for 3 hours.
Yeah.
125 members. Professionals attended from almost all
Largest ever meeting of the
SILF members.
members.
And you appointed a 5-member committee consisting of Ms. Pallavi Shroff, Mr. Jyoti Sagar, Mr. Mukesh Bhutani,
Lakshmi
Mr.
Kumaran,
Lakshmi Kumaran, Badri, to be able to look at what should be done to make sure that this Bar Council announcement moves forward, but moves forward with the right framework in place, and hence come up with the recommendations from SILF.
Yeah, I must put on record also, because you have referred to as to what happened in the meeting. There was one very strong view emerging from a few members that we should straightaway challenge these regulations. SILF should challenge these regulations in the courts and, you see, get some sort of a stay order against implementation. But then I said I don't want SILF to be taken, SILF to go to the court, because first thing is that we must try to have a dialogue with the regulator, that is the Bar Council of India, and they are conscious of the fact that there are certain deficiencies in their rules and regulations. There are certain anomalies which have to be set right, because immediately within one day, when the regulations were announced, they came out, you see, with some clarifications. Came out with about 8-9 clarifications. Foreign lawyers can only practice foreign law and all that, and which is not to be found, you see, in the main regulations. That means that they are open to some suggestions, because they have been issuing what we call the FAQs, in answer to FAQs. So they have been responding. So idea is to meet them, talk to them that these are certain anomalies which need to be set right, so that not only there is a level playing field created for the Indian legal professions, Indian law firm, but also to make it easy for the foreign law firms to practice here without any hindrances or possible litigation. The Prime Minister rightly says, ease of doing business. Now, ease of doing business definitely involves the legal profession. We have to facilitate that. We have to have a supportive role to this noble mission, you see, of ease of doing business. And the Prime Minister is right. Why India cannot be a hub of arbitration? Absolutely correct. Why people go to Singapore, or they go to Dubai, or they go to London or Paris for arbitration? You have to create that situation here which, you see, creates confidence among the parties. And when we are talking of globalization, globalization doesn't mean that globalization of economy without globalization of legal profession. But it should be on equitable terms, without sacrificing the interest of the
larger fraternity and community.
As what we call glocalization now. That is another phrase which has come.
Yeah.
That global plus local considerations, they have to be combined together to bring out, you see, the desired result. And for that purpose, a dialogue is very essential instead of going to the court. And I say, supposing the court takes an adverse view against you for any reason, then your doors are closed. then you are stuck with these regulations because they will say, now the court has pronounced, what can we do?
So
that was
dialogue
yeah.
is the right way to move
Right
forward.
way, yeah.
And the Prime Minister is a visionary leader. When he was the Chief Minister of Gujarat, he built the Gift City.
Yeah,
And
yeah,
look at
Gift
what has
City,
happened in the Gift City in the last 1 year. We will become a center for financial services in the world. It may take us a decade, 2 decades, but the fact is that process has been set in motion. That may happen to legal services too.
Very good example of gift you gave, because I visited them at the invitation of the Gujarat Maritime University. I think that has the potential of becoming a good center of resolving maritime international disputes. Those are the steps to be taken in the proper manner.
Now, Mr. Bhasin, let me ask you. Is it right to say that entry of foreign law firms in India is a done deal? There may be additions, changes, amendments, because even the regulator would like to implement it in the right way. Let's fast forward if it happens with the right recommendations, which are satisfactory and accepted by all Indian law firms. Do you think this move will benefit Indian law firms, or will it help the professionals? Who will it help more, the law firm or the partner in the law firm?
No, it will definitely help the law firm. But the first part of your of your question and your observation, that it is like a done deal. Definitely, so far Bar Council of India is concerned, it is a done deal. But can you anticipate that anyone will not go to the court, that this is against the Supreme Court judgment? We don't advocate, we will never be a party to that sort of a challenge. But anyone can go. A practicing lawyer who may be a partner or may not be a partner of a law firm, he can go to a court and say these rules are bad, they are against, the law laid down by the Supreme Court that only Indian citizens, so how can these foreigners be allowed? Therefore, subject to that caveat, subject to that, I think it is a done deal. And if someone decides not to go to the court, then one has to see how these can be implemented.
Absolutely.
And in what form and manner these have, not in the present form. The present form definitely, needs to undergo some changes, for which we are willing to sit with the Bar Council of India. I am already in touch, with the chairman of the Bar Council, very reasonable person, and we'll have meetings with them, with the executive of the Bar Council, and try to press forth our point of view.
So there is I interviewed a leading law firm's managing partner, and he said, I asked him directly, will you buy into Indian law firms? He said, the more likely we will acquire talent, if I may put it in my own words. How do you see this panning out? Imagine all the, your dialogue with the Bar Council is constructive, the right framework is in place. How do you see it playing out, and over what period of time? How do you see the next 12 to 36 months, so to say?
I just see it as more and more competent, efficient and large firms coming into India, without describing them as foreign law firms. I would put it this way, that we welcome more law firms coming from different jurisdictions, because that gives opportunities to our own people, particularly the young people, the young lawyers, to get familiarized, with what is happening contemporaneously all over the world. What are the global developments that will add value? And definitely it will be a right step. It will not hurt the Indian law firms, because, as I said, we stand on our own strength. We can face these challenges. If the foreign lawyers, if they come and they acquire Indian talent, we can also acquire some foreign talent, to...
I like that confidence.
Yeah.
I definitely believe that will happen.
That will happen.
There'll be collaboration, there'll be co-optation that you talk
yeah.
about. Now, you already alluded to the fact that because of this, India has the potential of becoming a arbitration center of the world. It should.
It should. Why not? Yeah.
What is the impact it will have on arbitration, so to say, matters in India? Because arbitration matters are huge. Especially if they involve large companies, the huge matters. So, do you see some work will go away from Indian law firms because it may go directly to these new entrants in the legal
No,
services?
the new
domain?
entrants are already allowed under the existing rules that they can come for arbitration matters. And even now it is happening because use of technology, there are foreign lawyers who are participating in arbitration proceedings,
Right.
where the arbitral tribunals are constituted under Indian law. So that will not hamper. I think that will rather promote and help in Indian arbitration people who are experts in different fields, not just judges and lawyers. We have architects, we have chartered accountants, we have company secretaries, engineers, bureaucrats. Why they can't? They will benefit out of it. And they are experts in their own respective fields. If there is a construction contract dispute, a judge or a lawyer, he can only interpret the law, no? But arbitration is more on facts, more on expert evidence. So that expert evidence is available not just with judges and lawyers, with other people also. Yeah. And Prime Minister is correct. India should become. But for that to happen, we should have good arbitral institutions. Government has now set up under Justice Hemant Gupta of the Supreme Court this International Arbitration Council. I had a meeting also with Justice Hemant Gupta. That is a right step. But then government should be like detached in the form, because it is the litigant also. It should be detached from that.
At an arm's length.
Yeah, at an arm's length. But at the same time, be very supportive, as is being done in Singapore. SIAC, which is the Singapore International Arbitration Center, that has achieved, this sort of a fame and name because the support of the government also. Their ministers of justice and all, they keep on coming to promote the SIAC in India. So support is there without interference. That is what is required.
Evangelism.
Yeah.
Let me ask you the last question. If you were a mid-sized law firm, law firms of SILF's members are pretty much representative of the all top-tier law firms, mid-sized law firms, smaller law firms. If you're a mid-sized law firm and you're looking to partner with a foreign law firm, what do you think? How should you prepare yourself? One, to be able to compete with them, and second, in some way, to deeper collaborate with them.
No, it all depends upon your relationship with your clients. You must have a binding relationship with your clients. The client should continue to have faith in you. And I think, so far Indian law firms are concerned, whether they are the big law firms or emerging law firms, they have excellent relations with their clients, because it is not just that they advise the clients on some particular issue. They become involved in the work practices, in the culture of their clients, because a lawyer must know something more about the business of the client than just the legal part of interpretation of contracts. Therefore, they have very good relations. If someone advises the Reliance, they must know what is Reliance all about.
So, do you think culturally, first of all, do you think culture that, because an Indian law firm and Indian law firm's partner, the professionals, the lawyers, they culturally understand how to deal with a client? I think, do you think that the law firms that are domestic, who have the competence, but more importantly, understand their clients culturally, will still have an advantage over a incoming foreign law firm?
Definitely they'll have an advantage, because we know basically it is all Indian culture, and our Indian law firms they have become attuned to, you see, what is the requirement of the clients. And it is very much clear now that a lawyer must know more than the client knows because of the research tools that are available. You see, today, the in-house lawyers and all, they do their research.
Right.
They go to the external counsel only if they find some vagueness, ambiguity, they are not sure. Therefore, a lawyer has to know more than what the client knows. And that is what creates confidence in the client.
Absolutely. And go beyond the brief. My last question to you before I end it. I think it's a very sensitive question. And let me ask it in a very sensitive way. We've seen in a lot of areas, branding has become very important. Today professionals talk of personal branding, there is internal employee branding, there is external brand. In every service domain, brands matter. And whether you take a Shardul Amarchand Mangaldas, you say a Cyril Amarchand Mangaldas, you take a Jyoti Sagar Associates, you take a AZB, you take all the other firms, like we talk of Mula and Mula, we talk of JB Dalachandji, these are legal brands. Do you think at some stage the regime to be able to represent yourself, present your credentials, I won't use the word marketing or business development, will also liberalize because of what has been allowed? Because the foreign law firms are very good at branding themselves. Whether it's being present in conferences, whether it's encouraging their partners to write books or TV appearances, so on and so forth. So do you think that regime of being able to allow law firms and law firm professionals to be able to market themselves will also happen in the next few years?
As I said, you see, there is a uneven playing field. For instance, as I said, in India, we can't even have our websites. In India, we can't have our entries in that, say, Legal 500 or other Martindale Hubble. That is all described as advertising. Now, what will happen? Because of the social media, these foreign law firms who establish their offices in India, they can, through social media, do all the indirect and direct advertising. Now, supposing Baker McKenzie comes here, Baker McKenzie say, we specialize in this, we do this, this is our achievement, we have done this is our rate. Indian firms can't do it. That is one of the points which we require to discuss with the Bar Council. How will you create that level playing field? There should be a clear prohibition. Mr. Batra, I am totally against this principle of marketing the legal, because I believe firmly, at least in India, I'm not talking about another country.
No, we're talking of India.
We are talking of India. India, we still consider this as a profession, not as a business. The branding and marketing and all these concepts, some law firms are doing it in India also. But frankly speaking, as president of SILF, I am totally opposed to such practices. You have your clientele, which should be based on the confidence that your client has in you. And then, if you are appearing in courts, the judgments will speak for you.
Absolutely.
This case was handled by such and such law firm. This case was handled by such and such law firm. Or this transaction, you see, was handled by this firm. This multi-million-dollar investment was done by this law firm. That is, it doesn't need branding. Then your work speaks for itself.
But certainly you feel that the law firm should be allowed to build their website,
yes,
have their credentials.
Of course.
That should be allowed.
That should be allowed, because that is not advertising or soliciting work. Someone sitting in Cape Town wants a lawyer in Kanpur. Now, if there is a proper website available and full information is available, those people will be able to get, you see, the appropriate law firm for their respective clients. But that should happen in a possible, reasonable way, not forgetting in India the legal profession has to give to the society, because we still believe in those values, in that traditions of legal profession being a noble profession.
Being a service to the society. On that note, thank you, Mr. Lalit Bhasin,
Thank you.
for talking to BW Legal World. I've enjoyed talking to you and learnt a bit in the process. I'm sure all our viewers.
I've also learned a lot from you.
Sir,
Your questions were so, compelling.
you're a kind person. I think that's the. But I'm sure watching Mr. Lalit Bhasin's interview on bwlegalworld.com will give you a peek into what will happen as the notification of the Bar Council comes into practice. I'm sure with SILF's recommendations to the Bar Council of India, it will create a framework for a smooth entry of foreign law firms in India in the right way, so that the best of legal services remain a profession and a social service, but also do justice to what a firm needs to do for its clients. I think the best way forward will happen, and I'm sure Mr. Lalit Bhasin's contribution in starting SILF in 2000, that's almost 23 years back, and taking a progressive view on allowing law firms in the right way will be historic. So we congratulate you on all your contributions.
Thank you.
And look forward to more conversations.
Thank you very much.
Thank you.